If you consider what is the goal of the rule, which is to protect client funds, protect client confidentiality, make sure there's rigorous safeguards in place. If the rule is silent, we should be able to leverage the newer techniques, especially if they are more effective and efficient at getting clients their money back.
Hello, and welcome to another episode of Financially Legal, the podcast for law firm CFOs. I'm your host, Emery Wager, co-founder of Confido Legal, an embedded payments platform specifically designed for the legal sector. Today, we have a really interesting conversation with Jayne Reardon. Jayne is the Deputy General Counsel of Fisher Broyles. She was the executive director of the Illinois Supreme Court Commission on Professionalism for many years. In that role, she led efforts to advance professionalism, civility, and ethics in the legal profession. She's a national thought leader on ethics and technology. And lately, she's been focusing a lot on how generative AI challenges traditional notions of lawyer competence and also client confidentiality. She helps advise legal technology companies on how their products interact with the rules of professional conduct. And she's a big advocate for modernizing ethics rules to better reflect the reality of today's technology-driven legal environment. Really interesting conversation. And as I reflect on the conversation and try to sum it up, Jayne was very clear that lawyers have a duty to do what's in the client's best interest. And that can mean, and often does mean, that lawyers need to understand and utilize the best technology in order to better serve their clients. But they also need to understand the risks and the downsides. Here's my conversation with Jayne Reardon. All right, Jayne, thank you so much for being here today. Let's start with a general technology question. The rules of professional conduct and rules in general, laws, regulations, just don't seem to be keeping pace very well with technology, specifically things like AI. We saw lawyers asking about whether they could accept cryptocurrency, for example, and oftentimes the rules of professional conduct, the ethics rules, are sort of behind the forefront of technology, and I don't see that ever changing necessarily. So talk a little bit about how lawyers should think about acting responsibly while also taking advantage of some of these technologies that are, of course, very powerful. And how does that lawyer ethically be on the forefront of technology?
So thanks for having me here, Emery. It's my pleasure to be here. You asked a very big question, and I think to table set, it's really important to understand that lawyers are bound by the rules of professional conduct that are passed by the state Supreme Courts. And they're very similar state to state in the US, but there's some differences as well. Those rules have not appreciably changed in dozens of years. So the rules were established in the early 1900s at a time where people lived quite differently, practiced law very locally, face to face. And so the rules were fashioned for a different time and place. And because you're dealing with laws and legal, we tend to be very bound by precedent, and they're very slow to change the rules. So what we have guiding lawyers' practice are rules of professional conduct and ethics opinions issued by state Supreme Court entities, including bar associations. They're behind the times. They're not keeping up with what's been going on lately, particularly with the advent of generative AI. But we've seen this happen Back when I first started practicing law, there was a big hullabaloo. Can we communicate via email? Ooh, I don't know. That might not be allowed. It might be this, it might be that, it might put our clients' confidentiality at risk. The same thing with how we store documents. Can we use the cloud? So with each technological advance, there's a fear, because lawyers are trained to mitigate risk, right? So
Hmm.
there's a fear. Can we take advantage of this technological advance and still comply with the rules of professional conduct? So the question becomes, when you're a lawyer and you want to take advantage of new technologies, is it going to help my clients? Is it going to make me more effective, more efficient? Am I going to reach more clients? Am I going to be able to deliver services better? And sometimes you can challenge the black letter rules, um, because you have to understand that the context in which they are written really may not apply. So I think it's a balancing act as you approach how do I practice ethically within these rules and still adapt to the modern times. So it's a bit of a challenge, but I think courts are getting the idea. There's been some rule changes, and we can talk about that. As you know, we consulted about your platform, and there's some movement, slow though it may be, to change the rules to allow new business techniques into the legal field.
Yeah, that's super interesting. So I think a lawyer could potentially argue that there are a lot of things out there that would generally help the clients, but they have downside. I mean, AI is a great example, so we can kind of sit here for a second. AI is a great tool to accelerate a lawyer and make them more effective, but there's plenty of downsides, issues, gotchas related to confidentiality and training, and what can I put into this chat GPT, and what can I not put into this. um, so how should a lawyer be thinking about, okay, this is a net positive for my client, but there's some kind of unknowns here, and I can't fall back on the ethics rules and say I was complying, if anything goes wrong necessarily, because it's sort of by definition, there's it's silent. So, what should lawyers, how should they be balancing the upside, the benefit to the client versus potential downsides?
Well, interestingly enough, on the issue of generative AI, there is a plethora of ethics opinions out there, including by the American Bar Association,
Hmm.
Ethics Opinion 512. Generative AI has caught us all flat footed,
Hmm.
because the promise and the opportunities are vastly different. Instead of just accelerating processes, making us able to do the same things faster and better,
Hmm.
generative AI, because of the generative nature, is a whole new animal. And after many lawyers have been sanctioned for failing to understand that this is a new kind of technology that requires more checking than some of the other ones. A lot of bar associations, I think there's at least 20 bar associations now, that have issued opinions. And I would say, I've read them all. I would say California and New York and maybe Florida are the three, besides the ABA, that give you the most guidance. What is helpful to understand is, as you point out, Emery, how to safeguard your client's confidential information. And what many people don't understand is what is considered confidential information is very, very broad. Most people would think, oh, it was a public filing. That's not confidential. Oh, yes, it is. Under the model rules 1.5, excuse me, 1.6, and many state counterparts, it's whatever your client might not want you to disclose. So you must be very careful about putting information into ChatGPT or any other generative AI tool if there's personally identifiable information there. So you might take out, let's say you're representing a corporation. If you take out the corporation's name, but in paragraph 3, you say this corporation has business headquarters in central Illinois on such and so street or whatever, you've now identified the client. So confidentiality is really, really big. The other issue that is huge, and I think it will very soon really challenge the paradigm of billing by the hour, is how do you bill for your time if you're a lawyer and you're using a generative AI tool that cuts the time it took you to review a contract, draft a contract, whatever, to a fraction of what it might be. You can't say, I would have spent 10 hours on this, so I'm going to bill 10 hours. Nope. If you bill by the hour, you have to bill just the time spent. And so that kind of incentivizes lawyers to move to value or flat fee billing and consider, what is the value I'm adding to the client? It's not
Yeah.
just the time put in.
Yeah. Yeah. And I think as clients become more wise to AI, I think initially when it was coming out, clients didn't like law firms that were using AI, but now I think a lot of clients would be disappointed in a firm that is not taking advantage of that speed and all of the benefits that come with it, and won't tolerate, you know, the old hourly accounting for things that should be done, almost instantaneously.
You're absolutely right. And that's another point to understand is, what is best practices? What are the ethical approaches do change over time, even if the rules do not. When I first started practicing law, it was very common for young lawyers, first year out, to go by the dozens to a warehouse and look through paper, bankers' boxes of paper to do due diligence for a deal. That would not be tolerated now. The computer assistance is the standard, so things will change, and they're going to change more and more rapidly
Mhm.
as time goes on, because the acceleration of change has just been monumental in the last couple of years.
I think that's a great sort of broad context for this particular discussion. We'll shift gears from AI and talk about another technology where the rules might be a little scant, but definitely close to home for us. For our listeners, Jayne did an amazing job working with us as we looked at the ethics of our digital disbursements feature, specifically designed for particularly the plaintiff space that is operating on contingency fees and needs to disperse to clients and other lien holders on a case. So let's talk about that in particular. Maybe you could just kind of set the scene a little bit, Jayne, with what do the rules say about dispersing money digitally?
Nothing. So, and I kid you not. Again, the rules were drafted long time ago, where there were not such things as electronic or digital payments, generally speaking. Um, there are rules about how lawyers must behave in handling client funds and property. I used to work for the disciplinary council for the state of Illinois, and the harshest penalties and discipline imposed on lawyers were if they mishandled client funds. And there are strict rules, all generally contained for the model rules, which are promulgated by the ABA. It's Model Rule 1.15. Each state has a similar rule. Sometimes it's numbered the same way, sometimes it's not. But most of that rule is focused on taking how a lawyer must take money in and hold it and safeguard it on behalf of the client. They have to make sure they don't commingle client funds with their operating account. They have to, and specifically your question was on disbursements, there's an obligation to promptly notify the client when you've received the funds, promptly deliver the funds to the client, and promptly provide an accounting of those funds upon request. And a lot of the states have very specific, stringent rules about record keeping and how you keep track of all of this. The overlay or underlay, whatever, is that you're handling this stuff with a bookkeeping book and journals and paper checks. That's kind of how it reads. That's how the comments read. But over the last several years, particularly here in Illinois, Wisconsin, California, some of the states have started to address electronic payments, mostly inbound. They're saying things like, lawyers can accept payments by Venmo or something other than ACH and checks. But the outbound situation really has a dearth of either rules or ethics opinions around it. And my position is, if you consider what is the goal of the rule, which is to protect client funds, protect client confidentiality, make sure there's rigorous safeguards in place. If the rule is silent, we should be able to leverage the newer techniques, especially if they are more effective and efficient at getting clients their money back. And so yeah, you should take a look at this rule and see how vague it is, Model Rule 1.15, and how much room there really is for improving what it means to promptly notify, deliver, and provide accounting to the clients. I want to point out one other thing around the word promptly. Here in Illinois and in many other states, there's a strict rule about when you can deliver client funds. Let's say you get it into your client trust account on a Wednesday, but it hasn't cleared. The funds are not yet available from that check to deliver to that client. You have to wait and make sure that the funds have cleared before you send a disbursement check by whatever means. Otherwise, it's considered conversion. Like if you have 100 or 1,000 or 10,000 client funds in your account, you can't just say, oh, there's plenty of money there, I'll pay client A, because if client A's settlement check has not cleared the other bank, you are actually possibly guilty of conversion. You can't use one client's money to pay another client. That is a bit arcane, if you will, but that is the rule in Illinois and in California, perhaps some other states as well.
Yeah, I mean, given how far behind our money transfer systems are in the U.S., it actually seems quite reasonable to me that you'd want to wait for that to clear. Given different banks are clearing ACH payments and checks at different times, making it available to you at different times. So someday at Confido we'll tackle that transaction, but that is not today.
Yeah.
If a firm wants to transition from paper checks to digital disbursements, let's say a personal injury firm that's doing a lot of settlement checks every month to clients, to lien holders, what if you had to kind of generalize, I know each state is different, Can you kind of walk through a checklist of things that you would do or that you might kind of advise a firm to do to just ensure that, like you said, they are um, maintaining kind of the record keeping obligations and complying with the rules while taking advantage of this new technology?
Yes, and a lot of it, Emery, is the same obligation you have if you have a bookkeeper, in the back office or 20 bookkeepers, right? Is make sure that each disbursement is authorized by a supervising lawyer and it's made to the right person. I mean, that's pretty basic, and that's going to apply whether it's paper or electronic. And so, if an electronic platform is providing that service, the lawyer should satisfy him or herself that the record keeping is in order and the lawyer has the ultimate responsibility under the ethical rules to make sure the money is getting to where it should be in the correct amounts. If there are transaction fees or costs, this is a little bit of a red flag to regulators because they want to make sure that any expenses or costs are clearly accepted by a client. So that's something that needs to be spelled out and preferably in writing, either in the engagement letter or in settlement documentation that the client agrees to pay this fee. They're paying for a convenience fee or whatever. So we already talked about making sure the funds have cleared and are actually available to disbursement. Basics: no commingling. Right, you've got to have the funds in a client trust account or an IOLTA account, non-IOLTA trust account, and the lawyer needs to satisfy themselves, whatever the system is, that the client funds are secure, that there are safeguards in place to protect the client's funds. That's important. And then, I think it's important, and some of the recent ethics opinions have said the lawyer should do what they can to satisfy themselves about the system, the program that's in place, and recognize that they have a duty to embrace new business techniques while protecting the client's funds. It can be done. And to put your head in the sand and say, we must protect the client funds by only using paper checks, I think will soon be outmoded, and it will be unethical to use checks under certain circumstances if electronic payments are in fact protecting the client's funds and accomplishing all of that protection while being more effective and efficient for the clients.
Yeah, no, that makes complete sense. I think to add on to that, if you look at the overall payment volume of checks, and then you look at the overall volume of check fraud, in a given year, it looks like it's around 30 basis points or 0.3%. So, in addition to what you were saying, it's almost checks are becoming an incredibly dangerous way to send money, especially with, to go back to the AI conversation, the ability to easily generate, a fake check using the account number and routing number. I talked to a firm the other day that got broken into, and the only thing taken were their checks,
Oh,
and they had to go through and change their bank accounts, which is not an easy thing to do. I have talked to multiple firms as we're, kind of bringing this product to market, saying, oh, in my state, we have to do things via paper check. And, we've done some kind of legal research in all the states. And disclaimer, this was not done through you. So I don't want to imply that this is your research in our state by state guide. But, and I know you have not looked at the rules in every single state necessarily. But do you, sitting here today, is there any way to kind of debunk that, or is it a rumor, or does it have some truth, or maybe you can't say from where you're sitting today, but I'd love you to weigh in on that.
I have to qualify it. You're absolutely right. I have not looked at all the states' rules and ethics opinions, because I'm pretty confident most states do not have this ensconced in a rule per se, but they may have ethics opinions. And what's important to understand is a lot of times the ethics opinions are written in response to a hypothetical or a situation that some lawyer writes into the bar association. I have this, that, and the other situation. Can I do it? And so they're very fact specific, and they aren't necessarily applicable across the board. I would hazard a guess that what is going on, if someone is telling you that, is the rules are silent, and the practice has been, which is true, you can't dispute, practice has been most lawyers are handling disbursements via check.
Yep.
But that practice is changing. So I think for the most part, there's not a requirement, but I'd have to, look at each rule. I think it's safer, right? As I said at the beginning, we're trained to mitigate risk. I know that I'm not going to get in trouble if I write a check. If I deal in some sort of, newfangled technology and it goes south, I might get disciplined. And those who are running regulations in the states are, generally older, more seasoned, shall I say, lawyers who aren't using newer technologies in their practice or in their home life. So it's unusual. And when things are unusual, they draw increased scrutiny. But I would challenge the notion that you must use paper checks. Increasingly, I think that will become not acceptable.
Some states have some language that say withdrawals shall be made only by check payable to a named payee, which of course, if you stopped there, that would that would be very clear. But it does say, or by authorized electronic transfer and not to cash. I think we found that in a few states. Any can you weigh in on the authorized transfer? What would be what would you say, like, how would we think about what would be an authorized electronic transfer?
That's interesting. I have not seen or analyzed that language, so I'm going off on a limb,
Yeah, I'm putting
which
you on the
ethics
spot here.
lawyers don't like to do. I'll be honest with you. Um, but generally speaking, authorized in this context, I would say if the lawyer has some sort of relationship with a bank or other financial institution, that would be an authorized transfer. Also, I think it's really important, especially if you're dealing with sophisticated clients. And I don't know if plaintiff's contingency cases would qualify that, but if the clients agree to a certain method of electronic payment, especially sophisticated business clients, I think that would probably be acceptable too. It'd be great to test into that because, again, the first part of the clause was probably left over from 1910 or whatever, and then they added that the state Supreme Court or whomever added the authorized payee. So you kind of have to look into the ethics rules to see what they consider authorized. Oftentimes, there's language about certain types of uh, financial institutions, et cetera, that are acceptable for depositing the funds into it. In terms of taking out, that's another issue that would need to be researched. That's interesting.
Let's zoom kind of way out, and just looking at the trends, you see the overall usage of checks going down actually pretty significantly across all industries. Law is not on the forefront of that plummet, but
That's kind.
but overall they are going down, and more um, methods of electronic payments that are faster, more secure are coming out, like FedNow and RTP in the United States. Um, it seems to me, if you zoom out kind of far enough, the check the the usage of checks to disperse money out of a trust account eventually will go away. It might take a long time, but just looking at the trends, it seems like that is the future. My question is, given how does that impact, going kind of back to the beginning, where the rules may be silent on a given topic or sparse, given that, kind of like AI, like obviously this is going to be the future. We are going to be using this. We sort of have to figure it out. If it's that clear where the future is headed, does that impact whether or not a law firm should be, or a lawyer should be, kind of exploring this technology, knowing that, and they may not know, but when I certainly zoom out, it looks like that's the way it's going.
I think now more than ever, it's really incumbent upon lawyers to um, maintain vigilance about the changing nature of the practice of law and adjust accordingly. So, in that sense, yes, I would say it behooves them. And I would say this, having worked in the court system for many, many years, it is actually quite surprising how amenable um, the courts are to input from practicing lawyers about the content of the rules. For example, there have been numerous courts across our country that have put together task forces on the future of the practice of law, considering what changes need to be made to the rules. As you probably know, changes have been made in some of the jurisdictions, allowing non-lawyers to go into business with lawyers, which is not allowed by Model Rule 5.4, for example, in Arizona, to a certain extent, Utah, now Puerto Rico, Washington, D.C. So the point is, if lawyers believe that the rules are standing in the way of progress that would allow them to be more effective and efficient and better serve clients, they should speak up through their bar association or otherwise to the state Supreme Court justices. So many justices have said, I don't know what's going on. You practicing lawyers need to tell us. And, some of the justices are very open to that and recognize that the rules are behind the times. So I would say stay involved and don't say, oh, I have to do it this way because that's the way it was ensconced in the rules in, 1920 or something, because I think we are changing, and it's really requires lawyers. We are a self-regulated profession, so our regulations are supposedly reflective of what we think should be the best approach. We are not victims here. We are active participants, and we need to act that way.
Interesting. Well, that's a great spot to leave that topic. Really appreciate all the commentary on the kind of the digital disbursements piece. I do want to totally shift gears, and I'm just curious. You're deputy general counsel for one of the top law firms in the country. What does that role involve? What?
So, a general counsel of a law firm generally is the lawyer for the law firm. And so there is a general counsel at my firm and most others. They're primarily involved in risk management. We were talking about AI, developing AI policies, developing other policies to keep the lawyers, at the cutting edge and compliant with the rules, reducing the risk of being liable for dropping the ball on, calendaring events or malpractice or whatever. My particular role as deputy general, there are a couple of deputies, is I focus on the litigation claims and insurance. So I'm handling those issues that come up. If a lawyer is involved in litigation and somebody's threatening a sanctions motion, or there are some legal cases against the firm, and I'm handling that. I'm overseeing outside counsel. I don't do the day-to-day litigation. So yeah, the general counsel's office is the one who's basically, that office is in charge of reducing risk to the lawyers in the firm. It's
Interesting.
interesting work.
And I should mention, I referenced this earlier, but you do great work advising technology companies in the legal tech space on how their products are, I should say, interacting with the rules of professional conduct. So I
I,
do want to give a big plug for the work that you've done.
oh, thank you, thank you. I actually enjoy that work a great deal because especially in the area of unauthorized practice of law, right? There's a lot of legal tech companies who are out there, and they have great products. They're delivering to consumers, and some of them are getting, attacked, if you will, by either state Supreme Courts or state's attorney general, because there's also statutes against the unauthorized practice of law. Talk about a set of rules that has not kept up with the times. In many states, it is considered the unauthorized practice of law, not only if somebody who is not a lawyer delivers legal services, but if a company delivers services that historically were performed by lawyers. And there is a really interesting area right now where you've got a lot of companies out there who can really help deliver services, especially now where there's so many legal deserts where people can't find lawyers to go to in their communities. Here in Illinois, we have the vast majority of our counties hardly have any lawyers per capita. So, so technology is the obvious solution, but companies have to be aware that if they affiliate with lawyers, the lawyers can get disciplined for aiding in the unauthorized practice of law, and the company could get sanctioned, um, uh, sometimes even criminally, for the unauthorized practice of law. So those rules
Wow.
really need to be changed. As I commented so many times, what does the practice of law mean when ChatGPT 4 can pass the bar exam in the top 10% of all test takers and in 6 minutes?
I was
So,
just going to ask you about that. If they're not marketing themselves as a legal, sort of a legal service, does that, kind of exonerate them, or
you know, it depends. It depends on how aggressive the state regulators and state's attorney general want to be on this issue. We've seen some real aggressive shutdowns in Florida and some of the other states. Other states, their regulators are pretty hands off. So it's a real fascinating field, and I love helping because I firmly believe that we lawyers can do a much better job, or lawyers with technology and with other professionals. It doesn't have to be just lawyers, in getting legal services to people who could benefit from it. It's really, I think it's a pox on our house that we have, so many of your middle class people who never even recognize that they have a legal problem or there is a legal solution. And lawyers are increasingly just providing services to the well-heeled corporations. And something should be done to change that. And I think something can be done because of technology advancing so rapidly.
Awesome. Awesome. Well, if you are a legal technology company looking to do that, I would highly recommend getting in touch with Jayne. What's the best way for folks to get in touch, Jayne?
Probably via my email at Fisher Broyles, jayne.reardon@fisherbroyles.com. Jayne with a Y.
Perfect. Well, Jayne, thank you so much for being here. Super informative. I learned so much from every conversation with you. So thank you very much. And
Thanks for having me, Emery. It's been fun.
Awesome. Thank you very much for joining us today. We drop these financially legal episodes every couple of weeks. You can get the most up-to-date information on financially legal by following Confido Legal on LinkedIn. If you prefer email, you can subscribe to our email list at confidolegal.com/financially legal. See you next time.